kind of impressive. So I only have a few matters on the calendar. The first one is J.G. Wentworth versus Tyja Dozier for a structured settlement matter. Who do I have here on that one? I see Miss Dozier. Mr. Kelly? Okay, you're muted. I just need to, I don't need you right now. There you go.
Yes.
Thank you.
Good morning,
Good morning. I'm going to have y'all run through that. I just want to make sure I had everybody right now, so you can stand down for just a moment. And then the next position I have is J.C. Rodriguez versus Brown's Construction, Johnny Brown and Tiffany Berry. Who do I have on that matter for J.C. Rodriguez?
Good morning, Your Honor. Chris Sargent for J.C. Rodriguez and Salme Fedor.
Okay. Judge, sorry.
That is the one with the interpreter, and I was just trying to interpret what was said. Can you hear me?
Yes, I can. In fact, I was unaware that we had the need for an interpreter, and so all I heard was both of you talking at the same time.
Yes.
And so is the interpreter for the benefit of Mr. and Mrs. Rodriguez?
Yes. And we were wondering,
la intérprete está aquí para el
interpretation on the phone, Mr. Rodriguez.
I need to interpret everything that's said. I'm sorry, Ms. Potter. Potter, I don't know if I'm pronouncing your name correct, but the interpreter has to say everything that's being said, and I haven't been able to do it. So the first part, when the judge came out, I'm going to say it. Buenos días a todos. Impresionante que estén aquí todos a las 9 de la mañana. Posteriormente dijeron que si el gasto es para la intérprete, no sabía que había intérprete, es para el señor y la señora Rodríguez, y este es el caso de J.C. Rodríguez, Juan Rodríguez, en contra de Construction Brown, creo que dijo.
Is it Miss Porter?
Yes.
Shall we ask the judge now? You asked me in the chat if it would be all right to do a direct interpretation using, I think you said his cell phone, so it'll shorten the length of the time of the hearing.
I don't have any, I don't have any problem with that, Ms. Porter, if you want to communicate that to Mr. Rodriguez and make sure that he's okay with that. I think that would shorten things, and the important part here is to make sure that Mr. Rodriguez understands the proceeding.
Right. And yet the only thing, Counselor, please make sure that he puts on mute the cell phone, because otherwise I'm going to hear the feedback since he's sitting right next to you. But I will go ahead and dial his cell phone number right now, and then he needs to put it on Do Not Disturb and on mute, if that is possible. Thank you. I'm calling him right now. That way it will shorten the time that you have to listen to me, and it will be a lot
Well, I don't mind, and it's important, but if we can make it more efficient for everybody, that's fine too.
Yes. Exactly.
While you're doing that, Ms. Porter, I did understand, I think I have a court reporter here.
¿Ya me oye? Pónganse en mudo, por favor.
Yes, ma'am. I'm here for this case.
Thank you, ma'am.
Yes,
and then I see Johnny Brown. Mr. Brown, do you have an attorney, sir?
Yes, I'm here on behalf of Mr. Brown, Johnny Brown, and Brown Construction. This is Leah Young.
Thank you, Ms. Young. I appreciate that. Okay. And so now I know who else here while Ms. Porter works out the logistics of that, the possibility of the direct translation. I'm going to see who else I have here for the other case, and then we'll get started. And then the other case I have is John Jones versus Bowen Brothers Garage. Who do I have here on behalf of John Jones?
Yes, Your Honor. It's Andrew Evans. I'm here for the plaintiff, John Jones.
Okay, Mr. Evans, you're super quiet. I don't think it's just me. So if when I call on you to present, I might need you to speak up a little bit or maybe get closer to the computer. Obviously, Mr. Evans, this is a default matter. So frequently that means the defendant will not be present. Have you had any contact with, or did you have any expectation that Bowen Brothers would appear today?
No, we have not had any contact with them, and we do not expect them to appear today.
Okay. So here's what I'm going to do. I am going to start with Mr. Kelly's matter, and then I'm going to let Mr. Evans present regarding the John Jones versus Bowen Brothers. And then I'll circle back and we will take up the Rodriguez versus Brown matter. So Mr. Kelly and Ms. Dozier, if you could unmute. And Mr. Kelly, if you would go ahead with your presentation, sir.
Okay. Ms. Dozier, raise your right hand, please. Do you swear or affirm that the testimony you are to give in the hearing of this case be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. State your name.
Tasia Dozier.
And Ms. Dozier, do you receive payments under an annuity?
Yes.
And why are you receiving that annuity? What happened to you?
Well, I don't have a place to stay. Kind of living in my car. Well,
Okay.
I am.
Okay, but were you injured in an accident?
Oh, no. My mom passed away when I was 7 years old.
Okay. So this was the result of a wrongful death case. Is that correct?
Yes, sir.
Okay. How old are you, ma'am?
23.
And how far did you go in school?
When I was 18, and then I just left again recently last summer in June, but I left because the FAFSA, my father's FAFSA is messed up because my older brother, he was at Howard, and I guess my dad owed a lot of money or something like that, and they tried to do like grants and stuff. I was I guess the word is appealed, or I was granted those grants, but I still needed more money, and I didn't have the money.
Okay. Did you get your high school diploma?
Yes, sir.
Okay. And you were taking courses and then you ran out of money, is that correct?
Yes, sir.
Okay. Now, you've entered into a contract with J.G. Wentworth to sell a portion of the annuity that you have. And what you're selling pursuant to the approval by the judge is one payment of $25,000, which is due on November 26, 2031. Is that correct?
Yes.
Okay. And what you've agreed to is a lump sum payment within the next couple of days of the amount of $7,000. Is that correct?
Yes.
Okay. Did you understand the contract you entered into?
Yes.
Okay. Did you get the advice of an attorney or a financial advisor as far as doing this sale?
Well,
Let me jump in, Ms. Dozier. This is Judge Krause. So what he wants to make sure is that you had an opportunity. You might have chosen not to, but he wants to make sure that you had an opportunity, that you understood, that you could have gone
Yes.
to a lawyer or a financial advisor and said, help me understand what the meaning is of taking this money now, et cetera. And so that's really what he's asking is, did you have an opportunity to do that?
Yes, I did.
Thank you, Judge. Now, Ms. Dozier, would you explain to the court why you're doing this? You're giving up $18,000 to get $7,000 within a couple of days. Why are you doing this? Explain to the judge why.
Because I don't have anywhere to live. I can't go to no family members. I can't stay with nobody. I'm living in my car. I tried getting rooms and stuff like hotels and stuff, but it'd be like $60 to $80 a day, and it's just a waste of money.
Okay. That's all I have, Your Honor.
But I do want to ask, I will have a remainder, correct, of $10K. I just want to make sure that's understood.
Yes, you have a remainder of $10,000 that you're not selling. That's all I have.
Okay.
Thank you. Ms. Dozier, well, first let me ask Mr. Kelly, if I'm not mistaken, have I met Ms. Dozier before? I thought that my staff attorney and I were discussing the fact that Ms. Dozier had appeared before me before to take money from her annuity before. I just wanted to make sure that I was
Yes,
remembering that
and that was,
correctly.
yes, and that was to purchase my car, which I'm in right now.
Okay,
I
understand.
purchased a car.
Okay, thank you, Ms. Dozier. I just wanted to make sure I was remembering that correctly.
Yes.
And primarily, Ms. Dozier, I mean, the purpose of these types of hearings, as I'm sure you probably remember that we discussed last time, is to make sure that you understand the import of, I mean, Mr. Kelly put a fine point on it. You're giving up the potential for 17 or 18 additional $1,000 in order, and I know, I'm certain that in whatever circumstance you're in, that $7,000 right now probably means a lot more to you than the idea of $25,000 in 2031. But really my job and what Mr. Kelly was presenting is to make sure that you understand what you are giving up.
Yes.
And that you're doing it, I mean, you can have whatever reason you want to have, but that you're doing it in an informed way, that you've made a reasoned decision.
Yeah, I didn't want to do this, but I really didn't have a choice. I don't have nowhere to go. So it's like at this point I had to just, tap in and do what I have to do.
Okay. Well, that is very unfortunate that you are placed in that position. I just hope that you are able, I think it's wise of you that you're aware there's a remainder part of this policy that's still there, or part of this annuity, that you're retaining that amount for. So that's a good thing. But as far as I am aware, Mr. Kelly, based on Ms. Dozier's answers to her discussion with me, her answers to your questions, it appears that she is making a reasoned decision with an understanding of what the facts are and the import of her decision, and having had the opportunity, though it seems that she declined to do so, which is her right, to speak to an independent attorney or financial advisor. And so I will approve and authorize the requested transaction. Mr. Kelly, I believe we have a proposed order from you, and so I'll go ahead and get that signed. Mr. Kelly, is that right?
My understanding as of last night, the proposed order hadn't been received by the attorney of record, John Rogers. Now, in the interim, he may have sent it to the court, but he will be sending to the court if he hasn't already done so.
Okay. Well, Mr. Freehoff, if you can reach out and make sure that we have the proposed order. As soon as we have it, we'll get it on record for Ms. Dozier.
Thank you very much, Your Honor. May we be excused, please?
Yes. Thank you, Mr. Kelly. Thank you, Ms. Dozier.
What'd you say?
I said thank you. You're able to log off now, ma'am.
Thank you. I did have a quick question. Would you know how soon I'll receive it?
All I can control is how long it takes me to get the order signed, and I'll get that order signed and filed today as soon as I have it. And once it gets signed and filed, it should be no more than a day before it pops up. And then from there, somebody else takes it, probably JG Wentworth, and figures out what to do with it from there. So.
Okay.
Thank you, Ms. Dozier. Have a good day. Good luck to you.
Thank you.
Okay. Mr. Evans.
Yes, Your Honor. Is the volume better?
Señor Evans, ¿está
I'm
mejor
sorry?
el volumen?
Ms. Porter?
Oh, I'm sorry.
That's okay. Oh, that's okay. I can hear you okay. So Mr. Jones, please go ahead.
Sure. We filed suit against Bowen Brothers. I represent the plaintiff, John Jones. We filed suit against Bowen Brothers for my client had paid $30,000 to have his vehicle upgraded. And the short story is just that Bowen Brothers did not perform any of the services that were paid for. My client paid $30,000 up front. I detailed in the complaint about all the calls and emails that were sent by my client trying to get updates on the case. And this is not the first time that Bowen Brothers has been sued. There's numerous cases where the allegations are the same, that he's taking money and not performing the services that he's been contracted for. So we attempted service several times, as is mentioned. in our motion for publication. The court granted that. Publication has been satisfied by publishing the notice as required under the statute. And so now we are here for the hearing on the default judgment.
Okay. Thank you, Mr. Evans. I will let you know that I have reviewed the docket, and it does appear that I signed an order in April of this year, allowing for service by publication, and that service was the publication was properly made with for the necessary time period. That more than 60 days has passed since the date of the order for service by publication, and no answer has been filed. And so it appears to me that Bowen Brothers is in default, and that more than 15 days has passed since then, such that Bowen Brothers is in default and they are no longer in a position to be able to open it as a matter of right. And so your client is entitled to a default judgment. The question for you and what information I need from you is really two things. One, if it was a contract amount, is there a liquidated amount? And then are there attorney's fees that you need to either present evidence or state in your place?
It is. And I spoke to my client last week about this. We were back and forth because we did have allegations in the complaint about unliquidated damages such as RICO. But after speaking with my client last week, he wanted to move for the liquidated damages only.
Okay.
Exhibit 1 to our complaint is evidence that Bowen Brothers accepted $30,000 on his behalf. I believe that satisfies the requirement for him to prove damages. So that's the $30,000 that we're asking for. There's an additional $5,000 in attorney fees that I will send the court evidence of, which includes my fee agreement with Mr. Jones, along with the deposited check, if that would satisfy the court for attorney fees. It's just a flat fee. There's no hourly wages that I would need to testify about reasonableness or anything under the statute. Because the fee agreement satisfies that along with the payment, we would just be asking for the $5,000 in attorney fees plus the $30,000 that was paid by Mr. Jones. We'll just keep it at a liquidated amount so that we don't need a trial on damages for RICO.
Okay. Thank you, Mr. Evans. I appreciate that. Forgive me if you have, and I have just not seen it yet, but given that you are planning to submit additional evidence regarding the $5,000 attorney's fees, I assume that means you probably have not sent me a proposed order, but if you would please make sure that what you're going to send to Mr. Freehoff, obviously file it as well, but whatever you send, if you can please email Mr. Freehoff a proposed order, and we will take it from there. I will tell you, I really prefer my default judgments to include the dates that I just outlined, so I typically like mine so that if we all go back and look a year from now, we have one place to look where it says, service was accomplished by publication and that it was accomplished on this date and that this person is in default, and then the amount was unliquidated or liquidated, et cetera. So that way we can have one document that will do everything, and I will enter that as a final default judgment as soon as we have it from you.
Yes, Your Honor. I'll be sure to include those dates and the necessary facts. Thank you.
Okay, excellent. Thank you so much, Mr. Evans. Is there anything else that you need from me, sir?
No, Your Honor.
Okay, have a good day.
May I be excused?
Yes.
Thank you.
Okay. Give me just one moment, counsel, to switch over to this matter so I can look at my docket. Okay. Thank you for that pause. I appreciate that. I needed to get into that case. Madam Court Reporter, I'm going to call the case now so you'll know that we're taken down, okay? This is going to be a hearing in the matter of J.C. Rodriguez Concrete Incorporated versus Brown's Construction and Commercial Renovation LLC, Johnny Brown and Tiffany Berry. Case number 25 CV 003049. I'll note for the record that Mr. Rodriguez, who I believe is the principal of Rodriguez Construction, is present here, and that by agreement of counsel, he primarily communicates and understands the Spanish language, and that the Spanish interpreter is here translating these proceedings for his benefit. Ms. Fodor, you represent Mr. Rodriguez, is that correct?
Yes, I wanted to make a point about the court reporter. So I believe that we called the court reporter here. And I just wanted to make sure that was on the record.
Okay, Ms. Young, are you planning to share and take down of the transcript if one is generated?
Yes, we would like to share and take down costs.
Okay, thank you. Okay. And then I will note for the record that Johnny Brown, who I believe and understand to be the principal for Commercial Renovation LLC, is also present here, along with his counsel, Ms. Young, who's just indicated that she will share and take down costs for the benefit of the court reporter. So this is on a default calendar. One of the reasons that I wanted to take a moment to go back and refamiliarize myself with the record is to make sure we're all in the same place, which is the record indicates that the lawsuit was filed back in March, that affidavits of service for Ms. Berry were filed on March the 20th, and then affidavits of service for Mr. Brown and Brown Construction were filed on the 26th of March. Albeit indicating service on the 24th of March, and that subsequently on the 24th of April, it looks as if the defendants, Mr. Brown and Brown Construction, filed a special answer. And then there was a motion to strike on the basis that the answer was untimely. I'm guessing because March has 31 days and therefore the 30th day would have been the 23rd of April, not the 24th of April, which is one of those odd facts that has failed many an attorney. In any event, I believe that is the procedural posture of the case and why we're here. Ms. Fodor, it is your motion in terms of your motion to strike and for default, if you want to go first.
Thank you, Judge. My colleague, Christopher Sargent, who entered appearance on Friday, he's with KF Law. He will be conducting the oral argument.
Oh, thank you, Mr. Sargent. Sorry, didn't mean to ignore you there, sir. And just for my record, and as the court reporter is taking down, Mr. Sargent is here also, as Ms. Fodor indicated, on behalf of J.C. Rodriguez. Go ahead, Mr. Sargent.
Thank you, Your Honor. We do have another motion for default pending against Defendant Berry. I did want to make a point of that as well, but
right. Well, that one was just less complicated because there's been no answer filed, and obviously more than 30 days have passed since service, and more than 15 days have passed since then. I don't know the status of any liquidated or unliquidated damages relative to that defendant, but you are correct that you would be entitled to a default judgment. Your client would be entitled to a default judgment as to Ms. Berry.
Thank you, Your Honor. And so with regard to our motion for default and motion to strike against the defendants, Johnny Brown and Brown's Construction, it's really a simple argument, Your Honor. They did file on the 31st day, 1 day late. Under 91155A, if you don't file within 30 days an answer, then you're automatically in default. In order to get out of default, you have 15 days to get out of default as a matter of right by filing a responsive pleading and by paying costs. And so really the thrust of our motion for default, Your Honor, was that they failed to pay costs. And in response, the defendants don't even bring up the issue of costs and argue that 30 days actually means 31 days to file a responsive pleading. We don't see that there's really any dispute here. As the case that we cited in our motion for default states, failure to pay costs is a statutory requirement to get out of default.
It's
And
a
if
statutory prerequisite. I mean, the case law is pretty clear that if costs aren't paid, the court doesn't have the authority to open the default.
Exactly, Your Honor. And so sitting here today, the defendants have failed to move to open default, have failed to pay costs, did not get out of default within the 15-day grace period. So, Your Honor, we seek a default judgment on our breach of contract claim against both defendants, Johnny Brown and Brown's Construction, jointly and severally. And that amount is liquidated. It's stated in our complaint as $47,180, Your Honor. We are also seeking attorney's fees on that amount and are prepared today to testify about our attorney's fees as well upon entry of the default judgment.
Okay, thank you.
Thank you.
Mr. Sargent. Ms. Young?
Yes. What opposing counsel has failed to mention that the statute says that it's exclusive of the date of the service of summons. So that means that the 30-day count does not start until the date after the summons is received. So if the summons was received on April 23rd, then the 30-day clock would not start until April 24th because it's exclusive of the date of the service of summons. And it says that in the statutory language. It also says that in the summons that was actually given to Johnny Brown and Brown's Construction. Furthermore, the service was improper, and we'll argue that further in our motion to dismiss. But in regards to it being in default, it was never in default because it's exclusive of the date of service of summons. Furthermore, in order for them to file a motion for default, there have to be no responsive pleadings previously filed. And that answer was filed on the 24th prior to their motion for default.
Okay. So, Ms. Young, I did read your responsive filing, and I was not being dismissive when I said this is a thing that has flummoxed many a lawyer. But the simple fact of the matter is I understand the argument that you are making regarding the counting of days, because I've had to do it plenty of times. But the simple fact of the matter is you're right. You start counting on the day after service, but when you count forward, that day is 30 days from the next day. Starting with that, when you count it physically on a calendar, what you end up with is the 23rd, I believe, of April and not the 24th of April. Regarding the other issue that you've asserted, you're absolutely entitled to file a motion to dismiss, particularly where you wish to challenge service. But Mr. Sargent's not wrong that the opportunity to open default as a matter of right has passed, right? It has to be done within 15 days. And that's pursuant to 9/11/55. Excuse me. And the filing of a motion to dismiss, I respectfully, I think that you're incorrect regarding the filing of a responsive pleading. While that works in federal court and it works in many other states, Georgia is oddly unique to the point that this is absolutely true. When I swear in new lawyers from other states, that is the advice I give them is go read 9/11/55 and familiarize yourself with Georgia's very weird default rules. Now, having said that, Ms. Young, Mr. Sargent is not wrong that J.C. Rodriguez is potentially entitled to a default judgment here based on what they have alleged and what they've documented. But I will tell you, Mr. Sargent, I have real concerns about entering a default judgment where someone is a day late. Granted, they've not taken advantage of the opportunity to open default, but I do question the extent to which the parties have had an opportunity to communicate. If there's been any discussion among the parties regarding a way to resolve this short of a default judgment. I have no information about the nature of the service, but particularly where part of the argument is that service was in some way insufficient. Mr. Sargent?
Your Honor, if I may, I'll start with the service issue. The service on the defendant Brown's Construction was perfected via Johnny Brown who in the answer that the defendants filed late, paragraph 5, they admit that he's the sole owner of Brown's Construction. As we put together in our response to their motion to dismiss, and we added as an exhibit, as an affidavit of non-service, we attempted to serve the registered agent 3 times. All 3 times, the registered agent was not at the office. Therefore, we then served Johnny Brown as pursuant to 911-4 as the owner, manager, and sole officer of Brown's Construction. That service was perfected. So there is really no question, Your Honor, about service being perfected on both defendants here. We have not had any discussions about settlement because we had discussions leading into this case, plenty of discussions trying to get this thing settled. Johnny Brown and Brown's Construction remained incalcitrant, remained unwilling to even discuss paying our $47,000 labor cost, Your Honor. And I will point out that in response to our motion for default judgment, the motion, again, is based on the idea that 30 days equals 31 days, doesn't get into what we told them about the payment of costs in our motion for default judgment. They never even addressed that issue in their response. And I'll also point out in their motion to dismiss, it is based on several, I would imagine, AI hallucinated type of language. There is language that was purportedly taken from a statute that doesn't exist. There are several cases that are cited that don't exist. We think that the bad faith on display here is pretty extensive. We don't see any reason to give the defendants any kind of mercy at this point. They've had several months now to move to open default, to make a showing under 911-55B of all the different elements that they have to show. They have failed to do it. They've sat on their hands. Apparently, they just read our response to their motion to dismiss because Ms. Young just this morning filed an errata notice admitting to the fact that some of the cases and citations in their motion to dismiss were non-existent. And so we believe that this is very ripe for default judgment, and there's really no need at this point to extend this matter further.
Thank you, Mr. Sargent. Ms. Young, I'm going to let you have the last word on this issue for now. Go ahead.
Yeah. In regards to the notice of errata that was filed, there was a particular case citation that was incorrectly cited in the initial motion to dismiss. That was corrected in the motion, the notice of errata, and it cites 2 additional cases that support the idea that are alleged in our motion to dismiss. First of all, that service was improper because it should be perfected on the registered agent. The statute 1411-1108 is the statute in reference to limited liability companies, and states that the registered agent is the agent for service of process, and it will be required to serve them first before pursuing any other means of service. Opposing counsel has made the argument that they have attempted to make service on the registered agent. However, no affidavits of non-service were filed or exist in the court docket that I can see, nor were they attached to the initial complaint in regards to the non-service of the registered agent. The only affidavits of service that were filed were in regards to Johnny Brown specifically on behalf of Brown's Construction. Furthermore, in regards to the motion to dismiss and the claims about unlicensed contracting and their recovery, opposing counsel states in their response motion that they don't believe that the Sachs case is relevant. However, I would disagree with that statement, only because of the quoted language, which talks about construing the statute liberally. And when I say statute, what I mean is 434117, which bars recovery for unlicensed contractors against owners. Opposing counsel has argued that they're not a contractor under the definition of 43-4125. However, they have neglected to mention the fact that they were performing contracting work, which is described under sections 4 and sections 9. Specifically, the work being performed was pouring concrete and building a slab wall. These types of projects are projects that would be required for licensure. So the statute is designed to protect the public from unlicensed contractors performing such work. Their arguments are that because they are a subcontractor, or sorry, their argument is that they're not a contractor and that they're not, this bar to recovery does not affect them because of the fact that they're not a contractor, and also the fact that the contract was not between them and the owner. The agreement, of course, was between the general contractor and the subcontractor, but if we're going to construe the statute liberally, like case law states, then we would take into consideration the fact that they are performing work that typically would require a license and are performing it as an unlicensed contractor.
Okay.
Now, I can't say for sure if they don't have a license, but from when we looked them up, we could not find one. I tried to reach out to opposing counsel in regards to that matter, and they did not mention having license for this particular project.
Okay. Thank you, Ms. Young. So most of the facts that you've just laid out for me would be a matter, I'm sure, ripe for much discussion and briefing if those issues had been raised timely. Here's where we are. Mr. Sargent is correct that the record indicates that, let me start with the easy one as we just discussed. The record indicates that Ms. Berry was served personally on the 16th day of March. That is docket number 7 in my file, and that she has never filed an answer in this case. Docket 8 and 9 indicate that Mr. Brown and Brown Construction were served on March the 24th, and that although there was an answer filed on April the 24th, it was 1 day late. Now, I've expressed my concerns about the fact that it is a default based on being 1 day late when in fact an answer was filed. But Mr. Sargent is correct that the case law and the statute, Georgia is unique in that when you reach the 31st day, you are automatically in default. There's no clerk's entry or anything else that has to happen. The individual or company that failed to answer is simply automatically in default. Now, there is a way to open that default as a matter of right within 15 days by paying costs and filing a responsive pleading. But again, as I mentioned a moment ago, the case law is pretty clear that the payment of costs is a statutory prerequisite, such that the case law is pretty clear that without the payment of costs, the court doesn't have the authority to open the default. And so it does appear to me that Mr. Brown and Brown Construction are in default. And therefore, Mr. Rodriguez would be entitled to a default judgment in some amounts. So I'm going to allow, there are a number of things we can do. Mr. Sargent has indicated that they are prepared to present evidence today regarding the amount of damages. Ms. Young, you and your client would be entitled, even though I'm saying that you're in default, you and your client would be entitled to present evidence or take issue with the amount of the damages evidence that is being presented. So you'd be able to cross-examine whatever witness he presented in that regard. Is that, Mr. Sargent, that's something that you indicated you were planning and prepared to do today. Is that correct?
Well, Your Honor, because the damages are liquidated,
Yes, sir.
we were not, on the breach of contract action, at least, we were
Okay,
not going to present evidence of damages.
I'm sorry, that's the $47,180. And
Yes,
then,
Your
but you
Honor.
mentioned something about attorney's fees. Are they also liquidated, or is it 13-1 or 13-611?
13-611, we are prepared to present evidence of attorney's fees, Your Honor.
Thank you. Yes, sir. I apologize. Okay. So, Mr. Sargent, are you planning to stay in your place?
Judge, may I clarify quickly? Did you also find Miss Berry was in default as a order?
Yeah, I started with her first because
Okay.
I don't have a dollar amount, but I started with her first because it was quite clear. There's no answer in the record at all. So
So all three are in default.
yes, that's correct.
Thank you. Sorry.
I know normally I don't say anything. I let my attorney speak, but I think I was served on the 24th. So that would make that day the 25th the next day, correct? So that would make us be in the right time. I'm listening to this, but if it's 30 days and I was served on the 24th, that would make the 25th be the day after, from my understanding, which would mean we did file in time enough, correct?
So, Mr. Brown, as I've just explained, I understand it's frustrating, and I have said before that the way lawyers count things is probably why people don't like lawyers. It's a good example, but the simple fact of the matter is that Ms. Young is correct that when you get served on the 24th, you start counting the first day is the 25th. But if you get a calendar right now and you start counting on the 25th of March, what you will find is that you will get to you will get to a shorter day. The 25th is the first day, and the deadline was the 23rd. I did the math when I got Ms. Young's motion. And I submit to you, sir, that we've all done the math correctly, and unfortunately, the answer that you filed was due the day before, not the day after. So it is, in fact, late under Georgia law. And that's because March has 31 days instead of 30. But I understand that's frustrating, and you and your attorney can take whatever steps you feel are necessary after this hearing. But for now, the court has determined that the parties are in default, and Mr. Sargent was going to present evidence regarding the attorney's fees that are being claimed. Mr. Sargent.
Thank you, Your Honor. I'm going to let my managing partner, Salme Fedor, take over from here on the attorney's fees issue.
Okay.
All right. Thank you.
Ms. Fedor.
Thank you, Judge. I've been practicing law since the late 90s. I've been licensed to practice law in Georgia since 2004, I believe. And I practice primarily in the Marietta area, although we have offices in Gwinnett and then in Fayette. We do practice also in several areas. One of the areas in which we practice is construction litigation. My billable rate is $4.85 an hour, which for an attorney of my experience in this area is a reasonable rate. Mr. Sargent has been practicing law since
2015.
2000. I was going to say, I think 10 years. He's been practicing with us for many of those years, most of those years. He bills at the rate of $4.50 an hour, which is an immensely reasonable rate for an attorney of his experience. We also have a paralegal who worked on this case. Her name is Tina Geiger. She has practiced with our firm more than 5 years, and her billable rate is $1.85 an hour. We had to expend a considerable amount of time. I'll tell you, a fair amount of our time was on the motion to dismiss, double checking and triple checking citations and quotes that didn't exist. And it took a fair amount of time to be sure that we were not missing anything there. We also, to begin with, when counsel, Ms. Young, reached out to us, telling us her argument about the licensure issue, we responded with a statutory language, letting her know our position. And then the motion to dismiss came anyway, with the terribly incorrect citations. So we spent a fair amount of time in this case putting together also the complaint. There were a number of invoices that needed to be gone through very carefully to make sure all of the figures were correct, to make sure our damages were correct and supported by all of the invoices. The total amount of legal fees, including today, $18,786. The total amount of costs, $1,055.26. It was very difficult to serve Brown Construction. As Mr. Chris Sargent referred, we tried several times at the registered agent location. We did file, of course, an affidavit of non-service on Brown Construction, before serving Mr. Brown. So we are asking for attorney's fees in $19,841.26. Is there any additional information you would like?
No, thank you. Have you,
I have a billing log I would like to present.
thank you very much. I hadn't quite
Thank you.
finished the thought yet, but if you had submitted any documentary evidence and whether or not that, given the circumstances, y'all had been in contact with Ms. Young at some point, if she was aware of those claim damages, et cetera, the claimed attorney's fees.
Well, we'd not given her the full amount of the attorney's fees. I mean,
Mhm.
quite frankly, we were surprised not to hear anything this entire time, about anything, about wanting to pay the liquidated damages. We haven't heard anything since we tried to explain why a motion to dismiss would not be appropriate in this case.
Okay.
And so if I may share my screen, Judge?
Yes.
I would like to, we timely submitted our exhibits and our proposed orders as ordered by the court. And I'm going to show our billing log, which we have labeled Plaintiff's Exhibit 2. And as soon as I find that,
I believe it's 20.
oh, Plaintiff's Exhibit 20. I'm just looking for the I hope we get the right screen. Is everyone looking at,
Yes.
is everyone looking?
Plaintiff's
at the
Exhibit
billing
20
log?
it appears to be a billing log for KF Law LLC from October 23rd of 24 through July 24th of 25.
Thank you, Judge. And this goes into great detail for each time entry. Every entry is true and correct. As Mr. Sargent said, I am the partner, I am the billing partner, and I have reviewed all of these entries and the work that was done. I can tell you the client has been billed this amount. We have a detailed explanation of the expenses and the total amount of fees. I tender Plaintiff's Exhibit 20.
Thank you, Ms. Young. Any objection to Plaintiff's Exhibit 20 being admitted? Ms. Young? Ms. Young, can you hear me? Ms. Fodor, can you take down your screen share now?
Yes, I can.
Thank you. Ms. Young, can you hear me?
Do you want me to try in the chat?
I don't know. Yeah, maybe that would be a good idea. Mr. Freehoff, are you there? Can you send Ms. Young a chat?
Yes,
Ask if she
Judge.
can hear us.
I'm seeing what you're seeing. She does have motion, so she's not frozen, but for
Right, but
some
it
reason.
seems, and her voice was also a little pixelated when she was addressing the court as well.
Okay.
Perhaps Mr. Brown has her phone number. I don't have her phone number.
Yes,
handy.
I'm attempting to call her now.
Thank you, Mr. Brown.
And then I have another exhibit.
Thank you, Ms. Fodor.
Yes.
Oh,
Can you hear me?
I can't.
Connection is bad. I can't. I want to join my phone.
Yeah, it's so, I don't know if you can hear me, Miss Young, but your connection is so bad that we really can't hear what you're saying. It might be worth logging out and logging back in to see if you can get a better connection. Mr. Freehoff, if you'll continue to communicate with Ms. Young if you can, I'm going to take about a 5-minute break to see if she can get logged out and logged back in. It's 9:50 right now. We're going to take a 5-minute break until 9:55.
Thank you, Judge.
Thank you. Okay. It is 9:55. Ms. Young, are you back? Are you able to hear me?
Yes, I'm on my phone. There you go. Can you hear me now?
Yes, I can. Thank you, Ms. Young. So where are we actually, where I think we lost you, I hope you were able to hear, was that Ms. Fodor had presented Exhibit 20, which was a log of her work. She'd shared it on the screen. Were you able to observe that?
I was not.
Were you not able to see it, or did you just not have a chance to read it when you say you weren't able to observe it?
To see it, the screen froze.
Oh, okay.
Yeah.
And so actually where we actually left off was if you had any objection to the admission of Exhibit 20, Ms. Fodor had offered it into evidence. And I think she also indicated that she had provided it ahead of the hearing in compliance with the court's order.
We did. We emailed it to the court and to council on Friday.
Ms. Young?
Yeah, I have no objections to that.
Thank you, Ms. Young. Ms. Fodor, you said you had another exhibit?
I'm just going to show one more exhibit, just reflecting that there was plenty of time for the defendants to try to make this right, to make some effort.
Can I step in, please? I did try to make this right for them.
Mr. Brown, please forgive me. I have allowed you to speak up because I know it is frustrating and sometimes people have questions, but you have a lawyer, and the way this is supposed to work, even if you wish to speak on your own, is not at a time when another lawyer is speaking. So after Ms. Fodor is done, I'm going to call on Ms. Young to let me know what she wants to respond to. And if at that time you wish to make a response of your own, although I often recommend against it, right, because you have a lawyer, but that would be the opportunity for you to do it. So it's not that you can't speak, it's just that it's not your turn just now, Mr. Brown. Do you understand that, sir?
I apologize, and it's just very frustrating because
I understand. I'm
I see
certain that it is.
I've done business with this guy a long time, and for it to be a money grab for like additional 30,000 on this job was just outright. But I'm done. I'll let my
Judge,
speak.
if
Yes,
we want to
Mr.
go
Brown.
into
Thank you, Mr. Brown.
what's not right about
Ms. Fodor, we don't need to go down that road. Mr. Brown was just expressing his frustration, and we have moved on, and we're going to continue with your attorney's fees presentation. Go ahead.
Thank you, Judge. I just wanted to show one more exhibit about how much time there has been for Mr. Brown to make this right. If I may share and show Plaintiff's Exhibit 9, it is a FedEx that this law firm sent regarding a lien that was placed on the property.
Okay.
It is, are we looking at the FedEx?
Yes, I am. I'm currently looking at something that's marked Plaintiff's Exhibit 9. Seems to be a FedEx overnight delivery from November of 2024.
Correct. And this was to Brown's Construction and to the owners of the property. And it's a materialman's lien, showing the lien that was placed on the property, the exact amount. So there was plenty of opportunity for this to be made right, or for any effort to resolve this issue. We also have the FedEx on the bottom of it.
Thank you. Ms. Young, any objection to Plaintiff's Exhibit 9?
No objections. Is this the filed copy?
This is the FedEx copy.
Go ahead, Ms. Fodor. Or if you're done with that, you can take it down.
Thank you, Judge. Let me stop sharing. As soon as
And so
Did
can
I
you
stop
tell?
sharing?
No, it's still there.
So sorry.
That's okay.
Why am I having trouble? It is still there?
Yes, ma'am.
Okay. I'm going to share Exhibit 3 and then stop sharing. I mean, I've done this a million times. I'm so sorry.
That's okay. The technology doesn't seem to be helping anybody today, so it's
Not
fine.
today. I so apologize, Judge. I don't have my stop share. It's as if it's not sharing on my screen.
Okay.
Oh, stop share. I just found it. Thank you, Judge.
There we go. Thank you.
My tender plaintiffs, was that admitted? Plaintiffs Exhibit 9?
I was about to say that it was. It is admitted, as was Plaintiff's Exhibit 20, if I didn't say that before.
Thank you, Judge. That's all we have for attorney's fees.
Okay, can you tell me the total? So the liquidated contract damage was $47,180. What is the
Correct.
total amount of the fees and costs that you were presenting?
$19,841.26.
And that's based on the $18,786 in attorney's fees
Correct.
and $1,055.26 in costs. Is that correct?
That is correct. Thank you.
Okay, thank you. Ms. Young, questions, response regarding what was presented by Ms. Fodor as to attorney's fees?
In regards to the itemization, did we see a itemization of it? Like I heard her mention the rates, but maybe that might be the part where my computer froze initially.
It is, but Ms. Fodor had also submitted them yesterday by email. It was a billing log that showed the time entries that her firm had expended, the amount of time that was spent, and the task that was completed.
And I'm so sorry, Judge, we submitted them Friday.
Thank you.
They were due yesterday, but we submitted them early.
Okay, Ms. Young?
Okay, thank you.
Any additional questions or argument, Ms. Young, regarding the attorney's fees?
No, Your Honor.
Okay. Okay. So as I said, I don't love entering a default judgment where someone's answer is a day late. But there is a procedure under Georgia law for the answer, even if, for example, Ms. Young and Mr. Brown disagreed with the motion, saying it's not late. You could still, but even if it was, here are our costs and here's our motion to open default, and then argue about it later. And that didn't happen here. And so unfortunately, as I've already indicated, based on the dates that appear in the docket, it does appear that Ms. Berry and Mr. Brown and Brown's Construction are in default, and that the liquidated amount of that, the contract damages for the construction work at issue of $47,180 is a liquidated amount that is recoverable, and the amount of the attorney's fees that have been presented to me in the total amount of fees and costs of $19,841.26 are recoverable under OCGA 13611, and that the amount of time and the hourly rate and the tasks that were performed appear to be reasonable and necessary, and that the hourly rate is itself also reasonable in the market. So for that reason, I am going to enter a default judgment as to the three defendants in that total amount. And Mr. Sargent, did I understand correctly that your request, or perhaps Ms. Fodor, was at least as to Brown and Brown's Construction, that judgment be joint and several? Was it also to be joint and several as to Ms. Berry as well?
Your Honor, the damages amount, I'm sorry, Salma, but yeah, the damages amount will be just against Johnny Brown and Brown's Construction. The only claim we brought against the owner, Defendant Berry, was an action to enforce the lien that was on the property.
Okay. And so what I will be looking for is a proposed order, or actually a proposed judgment, Ms. Fodor, and forgive me if you've already submitted one and I've just not had a chance to review it. But I think it would make sense to have one default judgment that lays out the appropriate circumstances. But given that the relief as to one versus the other is so different, if you want to do it in two proposed judgments, that's fine with me. But as you probably heard me say to someone else, if you would just make sure that the relevant dates are included so that we have one reference point. So what I will do then is look for a proposed judgment from plaintiff's counsel, and then I will get that on file as soon as I can it will certainly be this week. It will likely be today or tomorrow, depending on how quickly I get that order and have a chance to review it. And
Judge, there
then,
is one more aspect of damages. I apologize. It almost slipped my mind. We had requested in our default for pre-judgment interest at the legal rate of 7% and post-judgment interest at the legal rate, which I believe is prime +3, which
well, forgive me for interrupting. You would be entitled to post-judgment interest as a matter of course, from the date of the judgment, but I didn't hear anything. And if it's there and I did overlooked it, I apologize, but I didn't hear anything regarding an entitlement to pre-judgment interest, either based on the statutory factors or based on the contract. Can you address that, Ms. Fodor?
I think Mr. Sargent can address that.
Mr. Sargent?
Your Honor, as a contractual damages, we believe that the prejudgment interest statute applies from the date of the invoice. In our proposed order, we did calculate the prejudgment interest from the date of that $47,180 invoice. If you'd give me just a moment, Your Honor, I'll bring up that amount.
And while we're waiting on that, did we get a copy of the invoice that is being alleged in the damages?
We attached everything to the complaint.
Well,
I think we did.
just to make sure we're not stating anything incorrectly, we identified the invoice and the invoice numbers and the invoice amounts and the amount of work that was performed. Your clients received the invoices outside of litigation. If you want to take a look.
And no invoices were attached to the actual complaint as exhibits, correct?
Which I believe is why Mr. Sargent was correcting the statement and indicating that although they were referenced and outlined, they were not attached. So you're correct, Ms. Young, that they were not attached. But I believe what Mr. Sargent was saying is that Mr. Brown would have received them in the normal course of business.
Yes, Your Honor.
Mr. Sargent?
Yes, and so in our calculation from the date of the invoice at 7% per annum prejudgment interest, we calculated $2,476.95.
Okay. Okay. So thank you. I apologize, Ms. Fodor, for interrupting you a moment ago, but I appreciate, Mr. Sargent, that information. And it sounds as if you do have a proposed order or judgment that includes those amounts.
Yes, Your Honor. We will amend it just to add the information about Defendant Berry and specifically referencing the fact that our clients aren't going to move forward with the fraud and punitive damages claims. In the proposed order we submitted previously, we had carved out a reservation for a hearing on those damages. We're just going to move forward with what we got today, Your Honor. So we'll present a proposed judgment in the next day or so, Your Honor.
Thank you, Mr. Sargent. Ms. Young?
Your Honor, if I may, outside of the allegations in the complaint, there's been no evidence presented in regards to the damages relating to the invoice that's owed.
That's because those amounts are liquidated because they were stated in the complaint, and now the allegations of the complaint are deemed admitted because they were not disputed by a timely filed answer. And so that's why I was asking those questions about liquidated versus unliquidated. And so that's why. Anything else, Ms. Young?
That's all.
Okay. So in any event, based on the amounts, based on the liquidated amount in the complaint, plus the prejudgment interest and attorney's fees that have been presented to me, as I said, I am going to enter a final default judgment as to Mr. Brown and Brown Construction for those dollar amounts. And then as to Ms. Berry regarding the ability for those amounts to be enforced through a lien. I will look for a proposed order, and as soon as I have it, I will get it on file. And then once it's on file, Ms. Young, Mr. Brown, you can take whatever steps you wish to take to follow up to make sure that I have counted correctly and ruled legally appropriately. So anything else, Mr. Sargent?
No, Your Honor. That concludes
Anything
our
else?
business today.
Thank you. Anything else, Ms. Young?
No, Your Honor.